Welcome back to Do I Need a Lawyer? I'm your host, Gary Martin Hayes. Thank you for joining us. Now let's go to a question from one of our viewers. Gary, my wife and I were hurt in a car accident about a month ago. We were not at fault. I'm okay, but my wife is not. The other driver slammed into the passenger side door where she was riding. She's still treating with a doctor. We are already getting a lot of medical bills in the mail. If we hire a lawyer, what do we have to prove to be able to recover from the driver's insurance company? And that is from Jeff Indicator. Jeff, thanks for the question. I'm sorry to hear about your wife's injuries and certainly wish her all the best. Well, there are three things we have to prove in these personal injury claims. One, that someone was negligent in causing the wreck, and that's someone besides our client. Two, this person's negligence was the proximate cause of our client's injuries. And three, we have to prove the damages that our client sustained in the wreck. And this may sound somewhat complicated, so let me break down each of these three elements for you. Negligence. This is essentially means who is at fault. We have to prove that someone besides yourself was at fault for causing the wreck. The injured party has the burden of proof in showing that the defendant driver was negligent in causing the wreck. For example, when the defendant rear-ends your car because they did not maintain a safe following distance or they failed to keep a proper lookout of the road ahead, they were negligent. When the defendant rear-ends your car because he did not get his brakes repaired, even though he knew they weren't working properly, he's negligent. Other examples could include following too closely, driver distractions because someone's using a cell phone or texting or trying to adjust the radio, speeding or traveling too fast for conditions, tailgating, driving under the influence of alcohol or some illegal drug, failure to yield while turning left, driver fatigue because they drove their tractor trailer more than federal law allows. Proximate cause. Well, once we prove the other driver was negligent, then we must show that his negligence was the proximate cause of your injuries. And here's an example. You're at a complete stop at a red light. The defendant is not paying attention to the road ahead, and he crashes into the rear of your car. Your head hits the steering wheel, causing a huge cut on your chin, and you chip a couple of your teeth. The defendant's negligence was the proximate cause of the wreck and your injuries. Well, here's another example. You have a green light allowing you to proceed straight through the intersection. The defendant is traveling in the opposite direction. He doesn't see you and he attempts to turn left in front of your car and crashes into your vehicle. You sustain a broken arm and leg in the crash. Well, his failure to yield while turning left, that's the proximate cause of the collision and your injuries. The third thing is damages. When we prove that the defendant was negligent and his negligence was the proximate cause of the wreck, we must now prove what damages were inflicted upon you. And damages could include compensation for medical bills, which could include the ambulance, the emergency room physician, radiology bills, medical doctors and specialists, chiropractors, physical therapy, and prescriptions. And this is easy to prove as all of these healthcare providers, these suppliers, they're going to issue an itemized statement for the services they provide to our clients. Another thing, lost wages. Typically, if someone misses a week of work because of a car wreck, it can be proven with a couple of check stubs showing the time missed from work, a doctor's disability slip, and some kind of wage verification form signed by the employer. However, it can be very problematic if someone misses time from work but is paid, quote, under the table and there's no record on the books. It gets even messier when there's no mention of this work on the tax returns. Other things that we can recover, transportation costs. Look, you wouldn't have to be going all over town driving to doctor's appointments, physical therapy appointments, getting your prescriptions filled at the pharmacy if the defendant had not caused the wreck. This is clearly money that is coming out of your pocket you would not have lost if the car wreck never happened, and you should be compensated for this loss. Gas is expensive. Parking in some of the private lots can also add up, so keep track of your round-trip mileage to these appointments and save those parking receipts. Future medical expenses. No one has a crystal ball to tell you everything the future is going to hold for you medically. However, doctors can sometimes tell us to what we call a reasonable degree of medical certainty what they anticipate you will incur should you eventually need a surgery or have to undergo some additional test or treatment. The key component to making a claim for these future medical expenses is to get a doctor's narrative addressing the medical needs, why they're necessary, how they were caused by the wreck, and then the cost associated with the procedures. Future lost wages. The standard for proving future lost wages is simple, yet it can sometimes be a difficult hurdle to overcome. The way a jury measures future lost income is for them to determine what the plaintiff would otherwise have earned in his job or profession but for the injury. The future lost earnings cannot be speculative, and you must have documentation substantiate your claims. In punitive damages, sometimes the defendant's conduct in causing the wreck or his actions immediately after the wreck are so egregious the law allows us to seek additional damages to punish him. And finally, general damages. These are designed to compensate an injured victim for losses such as pain and suffering, emotional suffering, hardship, or inconvenience. I mean, there is a lot that an attorney can pursue on your behalf, but you got to call the attorney. Do not try and take on the insurance company and their lawyers by yourself. Folks, we'd be more than happy to talk to you about your particular claim. The phone call is free. The consultation is free. There's no obligation. It's completely confidential. But we can't call you. Pick up the phone and call us, 770-934-8000 or Gary at GaryMartinHayes.com, and we'll be right back in just a moment.